Welcome everyone to the 2025 ICHP Law Update. It is titled the Illinois Regulatory and Law Update 2025. My name is Chris Crank. I'm the Executive Vice President for the Illinois Council of Health System Pharmacists. The goal really today is to talk about what's new from a rule standpoint or a regulation standpoint in 2025, as well as actual public acts or laws that were signed into effect in 2025 in Illinois. From a conflict of interest standpoint, neither I nor my spouse have any potential or real conflicts of interest related to this activity. What I'm hoping, many of you who have been on my law reviews before know that I like to talk about how do you find your Illinois representative and senator, because that's the first part of getting active in advocacy. We're going to see where can pharmacists, technicians, and students look up proposed legislation. We all occasionally throughout the year will hear, hey, there's this piece of legislation that's been proposed and it does X, Y, Z. And then, that creates concern, or maybe you're happy because of a change that's coming. I'll show you how you can look for that legislation yourself. And then the other thing, we're going to talk, like I said, what is changing in Illinois in terms of rules and laws for 2025. What this basically is this is the Illinois State Board of Elections. And you can put in your work address or your home address, and you're able to find out who your Illinois state senator is, who your Illinois state representative is, as well as on the federal level, you can figure out who your representative is. And we have our two senators that everybody in Illinois shares. And so this is the first step from an advocacy standpoint, is getting to know who are your legislators. We're going to talk a little bit about advocacy at the end of the presentation, but one of the keys is building relationships with your legislators. What you don't want is the very first time you talk to your legislator to be when you need something from them. You're a constituent. They are going to be interested in hearing from you, but very similar to you, the first time you meet somebody, if they have an ask of you, it's going to be a different relationship or a different interaction than if it's somebody you've known for a long period of time, or you have at least some ongoing communication with, even if it's right. Your legislator may not become your best friend, but if you have a working relationship with them, when you have an ask or a question, they're going to know who you are and they'll be much more likely to listen. What we did, right, when you pull this up, you're going to see your state of Illinois and you put in an address. What I've done is I've put in the ICHP office address here, 4055 North Perryville Road in Loves Park. Like we said, it pulls up both your state representative, your state senator, and your federal representatives as well, or federal representative and federal senators. And that's what we have here for right now. The two Illinois senators on the federal level for Illinois are Dick Durbin and Tammy Duckworth. Senator Durbin has announced that he is planning on retiring, so this will change at some point. When you dig in a little bit, you can see Dave Vella is the Illinois state representative for the Loves Park office. And so you can see the outline of the district. People have asked me to explain how the districts are drawn out like this. Why aren't they squares? Why aren't they more uniform? That's a good question. There's a lot of boundaries that change and evolve over time. It's also important to periodically pay attention to the news or look at this information because, as an example, my U.S. representative used to be Sean Caston, and about a year and a half or 2 years ago, it switched over to Bill Foster because districts were redrawn. And so things can change. Who can put in the chat who their Illinois state senator is? So not their federal senators, but their Illinois state senators. Good, people are coming in. Yes. So I see a lot of state senators that I recognize. Good. I think I do this at every law presentation just because I want people to have an idea of who represents them, right? Who is their senator? Who is their Illinois representative as well? That's really the first step. It can be hard to engage, right? Because politics can feel kind of like, well, wait. I'll just say it. They can feel kind of dirty, right? Like, well, wait, there's a lot of money in politics. I don't know if I should be involved. I think pharmacy professionals, to some degree, we need to get past that and realize that we're never going to be able to compete with the money anyway of pharma or PBMs or insurance companies. But if you don't advocate for yourself and your profession, it's hard for those people, right? Those people who are elected to represent you to do that. And so, one of the easy ways to get involved and have first contact with your senator or representative is they almost all have what I call coffee talks, right? They'll be at the local coffee shop or the local civic center on a Saturday. It's an opportunity. Yes, you have to take some of your time, but it's an opportunity. You can go and meet them, see what their stances are on issues, as well as provide some feedback as a citizen number one, right? It can be any issue that you have, but also as pharmacy professionals, challenges that we are facing, right? Don't assume that your state legislators always know or fully understand the issues that we face in health system pharmacy practice. I think they have a pretty good idea. Like we're going to talk about PBMs today. We're going to talk about, white bagging a little bit, some other aspects. But that takes a lot of contact with those legislators to get them to even, start to understand what the issues are in healthcare. So the more of us that are talking to our individual legislators about the issues, the more likely we are to see traction on some of the challenges that we face. Unfortunately, talking to them doesn't guarantee you're going to see the change you want either, right? That's the way the legislature is set up to work. But it doesn't mean you don't still try to plead your case and explain why change is needed. One of the other things that I always highlight is the Pharmacy Practice Act. I suggest that once a year, every pharmacy professional in Illinois check out the Pharmacy Practice Act. It's also a good reason to be, in my opinion, to be involved with ICHP or an organization is that, you'll get updates on what's changing in the law too. But as a pharmacy professional, it's your responsibility ultimately to know what laws impact your practice in the state of Illinois. We did recently, right, not too many years ago, have a major revision of the Pharmacy Practice Act. It's set to be repealed on January 1st, 2028. That doesn't mean it's going away. That means that there has to be some action taken on it to evaluate if the language is still appropriate by January 1st, 2028. There's often confusion on this. That does not mean we can't change the Pharmacy Practice Act until January 1st, 2028 either. We can change it during any legislative session if we can convince legislators of of the changes that are necessary. So we have a chance to update the Pharmacy Practice Act every year. The other side, right? I always talk about the law, right? The Pharmacy Practice Act is the policy. It's the guiding, overarching document that we must follow, right? That language that we have to follow. The Joint Committee on Administrative Rules puts together rules that govern pharmacy. Rules are the regulations. I think of them as the procedures. So we talked about the law being the policy. The rules are the procedure. The how do you stay compliant with the law? So you'll get in Part 1330 on JCAR, you get a lot of the details of what a PIC has to do. What are the requirements of a PIC when they leave a role, right? And they're no longer going to be the pharmacist in charge. What do they need to do to stay compliant with the department? So we did get rules published in First Notice, updated rules on April 18th of 2025. First Notice rules have to stay in First Notice for a minimum of 45 days. If anybody is doing the math or calculating the dates in their head, we are well beyond the 45-day wait period for those rules that were introduced in April to be published in the Illinois Register in Second Notice. What we're hearing is these new rules are supposed to be published in Second Notice sometime in December. So the minimum amount of time for new rules after First Notice to take effect is 45 days. In Illinois, very often, right now we're looking at probably 8 months for rules to go into effect. That's not optimal, but that is the way sometimes that Illinois operates. So the Illinois Register from April 18th with all the rules that are proposed are listed there at that link. This is just an example. Now, it looks a little different now. Illinois updated their website, but this is what the rules section looks like. So you can see they have Subpart A, which is more general provisions. Part B is pharmacy technician related. Part C is pharmacist related. So each of these sections has regulations and rules related to whatever the title of that section is. Here's some of the updates. So what was proposed in these April 18th, 2025 rules that have been in first notice? Well, one of the first things is an update in the fees for license renewal and license application in Illinois. Unfortunately, the Illinois Fund for Pharmacists and Technicians was looking like it is going to go bankrupt in 2027 if fees were not increased. So IDFPR has proposed in rule new fees. I'm happy to say technicians, the application fee did increase, unfortunately, but it went from $40 to $50 per year. Renewal went from the $25 up to $35. So again, another $10 increase in renewal in that scenario. So it's no longer a $40 application, I should say. It's now a $50 application for initial licensure. And then the renewal went up to $35. Pharmacist application's a different story. It's going from $75 to apply to $400. The cost for an every 2-year renewal, so I put this in the 2-year context. Right now it's $150 every 2 years. It's going up to $350 to renew your license every 2 years. New license application going from $100 to $600. And then the pharmacy license renewal. So for my directors of pharmacy on the call, or the managers or assistant directors, the licensing fee for your pharmacy license is going up to $250 per year. So what that means is when you renew that every 2 years, it's going to be a $500 fee to renew your pharmacy license. I don't think anybody loves these increases. I'll start with that. However, what IDFPR would go back to with this is that if they didn't increase fees, the pharmacy fund was going to go insolvent. And so it's a necessary change. It doesn't make anybody feel any better. This does bring us in line with what other larger states charge for licensing fees. We're now more in line with New York and California and other states that are our size. This is a proposed rule. We're still waiting for that December publication to know what it's really going to be. Some other updates out there. They did add language. This seems like it would just make sense. Section 1330 for unprofessional conduct added a statement that if you don't respond to a department subpoena within 60 days, that would be viewed as unprofessional conduct. Renewals. It's important, right? There have been a few licensees who have not renewed their license, and their response to the board and IDFPR for not renewing was, well, that's not my email address anymore. That's not an acceptable response to IDFPR or the board. So the board has said, well, now you must update your email with us. So that's in the rules. Restoration of license, there wasn't a great process for technicians to restore licenses. So if somebody worked as a technician for a few years, went and worked in another field for a few years, and then wanted to come back, the restoration process wasn't as well outlined as it should have been. They've added language now that applies in the rules to technicians for restoration of license too. One thing that I would highlight, test and treat. So test and treat and therapeutics that were added to the Pharmacy Practice Act in terms of influenza, COVID, group A strep, RSV, and head lice. There are now proposed rules that should be, again, in December, that would outline what is required for test to treat. There's some information in the proposed rules that would cover delegation of tasks to technicians, the requirement of basic life support certifications, and then also record keeping and forms that might need to be used or information that would need to be collected to take care of those patients. So I definitely, once these are in final notice or second notice, I will provide an update to the ICHP membership about it. The other thing is pharmacy technician training. Section 1330.210, it really looked at some administrative and technical tasks of performing the test in the test and treat and added some language there. One thing in Illinois, we do have 3 ways that you can onboard new technicians, right? It creates all kinds of confusion, but there are 3 ways. 500 hours of on-the-job training that cover the 6 areas that are listed in the Pharmacy Practice Act is number 1. Number 2 is considered in 1330.215. It's an in-between step between fully accredited ASHP, ACPE training and the 500 hours of on-the-job training. What they did is they clarified when they say didactic education is required, what does that look like? It's 100 hours of didactic education. So there's the three ways: 500 hours on the job, highlighting the 6 areas of practice, complying with 1332.15, and then any technician who has completed a fully accredited ASHP, ACPE program would also meet the training requirements in Illinois. I'm happy to say that Section 1332.30 is going to be updated. That's the CE requirements for certified pharmacy technicians, that it's going to go back to 1 hour every 2 years for patient safety and law. There was an error in the writing or the language for the rules in Illinois where technicians were being required every year to get a patient safety and a law CE. If this gets approved in December, we should see that go back to the national standard for CE hours. 1330.500 is another important update. I think when it comes to sharing, right? We all face shortages or stockouts, and sometimes we borrow drugs. This is going to require that pharmacies have some type of an invoice to track that transfer of drug. There's also some updates, some basic updates for telepharmacy, that it doesn't have to be a separate room, that it just has to be a separate area for consultation for telehealth services. Section 1330.520 was updated when it comes to off-site institutional pharmacy services. The reason why it was updated was related to Section 1330.570, outpatient clinic pharmacy services. I wish IDFPR would have chosen a better name for this. This is not pertaining to pharmacists practicing in ambulatory care in a diabetes clinic, right, or an endocrine clinic, or in an outpatient clinic where they are managing hypertension or CHF, or, like I said, diabetes. This pertains to pharmacies that care for an off-site clinic or an off-site service like an ambulatory surgical center or an ambulatory infusion center that isn't really owned by your organization that owns the pharmacy, but you're providing pharmacy services to them. What it does is it brings some of the off-site institutional requirements to those pharmacies that are providing those types of services. We'll have to wait and see what the final rules look like for this. But if you do service an outside ambulatory surgery center or others, you really want to take a look at Section 1330.570 when it's finalized to make sure that you're in compliance with the new requirements. The other thing is remodeling. There's always been a question of, does a remodel require me to reach out to IDFPR to discuss it? Section 1336.10 has been updated to say, yes, it does require that you reach out to the department. Whether they will need to have an on-site visit or not depends on what type of a remodel you're doing or how extensive it is. The other thing with that, I think IDFPR is working with their inspectors to figure out how can they make this process more uniform and more consistent, because there are inconsistencies in when a full on-site inspection has been required versus, no, that's okay, just submit the paperwork and the plans and we can approve that remotely. So I know Stephen Smith at IDFPR is trying to get that to be a more uniform process where everybody knows what to expect and it's consistent each time and between inspectors. One thing that has come up, there's a big change in the pharmacist in charge language, but it's really not as big as it looks. What it did is there were cases where pharmacists in charge would leave a pharmacy, right? They go and they're employed someplace else and they wouldn't notify the department. That's an issue. The pharmacist in charge, if you are a pharmacist in charge and you are leaving your current role and you're no longer going to be the pharmacist in charge, you should let the department know that you are leaving that role and you are no longer the pharmacist in charge. Number one, it's required in the rules. And number two, it protects you as the pharmacist in charge that you're leaving, because then the department knows that you are, after that date, no longer responsible for what happens in that pharmacy. Language that was added was related to the pharmacy license holder, Walgreens, CVS, the health system itself, the hospital. also has responsibility for selecting a new pick and letting the department know about who is now the pharmacist in charge when there's a change. What was happening with our retail colleagues, somebody would leave a Walgreens or a CVS or any other store and they wouldn't get updated. There was no pick. And an error would occur or an issue or a complaint. And then 6 months later, the department reaches out to the old pharmacist in charge, right? The prior pharmacist in charge, I should say. And that pharmacist in charge said, I left 6 months ago. I'm not responsible for what's going on there. So this is a mechanism for the department that both the pharmacy license holder and the PIC need to notify them of those changes. And so that eliminates the pharmacy license holder from being able to say, well, it's the PIC's responsibility, it's not ours. It puts the responsibility on both. The 133680 automated dispensing and storage systems was also updated, related to the outpatient clinic pharmacy. So if you do have a surgical center that you're supporting in that contract kind of arrangement where it's not your own, your organization does not own that surgical center, you need to look and make sure that, right, you're following all the same procedures you would for your automated dispensing systems at that remote site. And then this is related, it's a small change, but an important one to section 133700 on patient counseling. The new rules that are proposed would change it from a new prescription requiring counseling to a new drug. That's very important because, right, did you have to provide that counseling every single time the person's lisinopril got renewed each year? No. The intent of the patient counseling requirement, if this is approved, would be that when somebody starts a new therapy, counseling has to be offered to the patient at that time. So it's a small change in the language, but it really means new therapies need an offer of education by a pharmacist. Centralized fill is becoming more and more common, both in the community and in health systems. And there are some updates in the central fill requirements too. Too much to go over in this presentation, but what I would say is there are expectations on policies and procedures in the rules that are outlined, record keeping requirements, as well as delivery of the medications and the distribution of the meds requirements related to that. And so when this gets finalized, if you have a central fill process at your organization, section 1330-770 is one that you're going to have to take a look at to figure out, are we in compliance with the rules? The last rule, this is not proposed yet even. This is IDFPR working with ICHP and IPHA to outline a plan for technicians. It's a good change. IDFPR is going to switch to a 4 license type technician licensure. Some of you on the call are probably like, wait, they're having trouble tracking one type of license. Isn't 4 going to be even worse? I think initially, maybe. I think there's going to be some growing pains and some challenges with 4 license types for technicians. But they're trying to address some of the issues with technician licensure in Illinois. Number one, right? Individuals who were licensed as a technician prior to the 1/1/2008 requirement for certification. Those individuals will move from a 049 licensure that you can see here over to a 069 code. So when you're hiring somebody who's worked as a pharmacy technician for many years, if you're in that hiring position or role and you see that their technician license starts in 069, you will know that they do not have to be certified per the state of Illinois. You might require it as an organization, right? Your health system might require techs to be certified, but Illinois would not require that person to become certified to continue to practice. 039 is the certified pharmacy technicians. So this would be the license class of most of our pharmacy technicians in Illinois. People who have been working for more than 2 years and who are required to be certified would have the 039 license code. 079 addresses student pharmacists. For many years, there's been a lot of discussion back and forth of, wait, I have student interns and they're in pharmacy school. They're a technician, but yet they're different. What are the requirements and how do they apply? 079 is, in theory, an answer to that problem where student pharmacists who work as technicians in pharmacies would get the 079 code. And then the 049 code would remain in place, but this would be for newly practicing pharmacy technicians in Illinois. So if you're a 16-year-old in high school and you start working in a pharmacy, your license code would be 049. And within 2 years, you would need to be switched to that 039 code because you became certified. So 049 is going to become a temporary license code for those that are newly licensed in Illinois as pharmacy technicians. One of the other great things, in my opinion, they're all going to go to 2-year renewals too. So the renewal period will go to a 2-year renewal on even years, just like the pharmacist. So primary source verification will switch to every 2 years for health systems for technicians too. So we spent a fair amount of time on rules because there's a lot of pharmacy practice rules that have been updated. But we do also have some pharmacy legislation or healthcare related legislation too that's being updated. The current legislative session is the 104th General Assembly. It's a 2-year period. People get confused a lot because what happens is the 104th General Assembly is going to be 2025 session and 2026 session. January of 2027 will start the 105th General Assembly. This is, if you go to ilga.gov/legislation, you can pull up proposed legislation and bills from that session. You can also use the link here that's the ilga.gov previous usga.asap or ASP. That'll take you to prior sessions as well that you can look up. So when you pull up that website, this is what you'll see. This was from the 2025 session. So yes, there were 2,671 Senate bills proposed in Illinois in 2025, and there were 4,150 House of Representatives bills, so House bills. And so it's a large amount of legislation at any one point in time that's being proposed in Illinois. Now, this is everything. This is not healthcare legislation only. This is all bills. But we do have to review all of these bills to see if they have implications in Illinois. So when you drill into the individual bills, you get a list like this, and you can see this is House Bill 1686 through House Bill 1700. You can then click on these bills, they're all hyperlinks, and it will take you into the specific bill. And what you'll see is you've got the bill status of House Bill 1697. We're going to talk about this one some more. The bill status is listed, so you can see it became Public Act 104-0027. That means it's law in Illinois. If it didn't get out of a particular chamber, there are also updates. What is the latest thing that's happened will be listed there. If you want to look at the full text of the bill, you can click here. If you want to look at the vote, like who voted for it and who voted against it, you can look. Who provided witness slips in favor or in opposition or that were neutral. And then a printer-friendly version as well. When you pull up these bills, they can be very, very short. So they can be a single paragraph. Or they can be 287 pages. Because the changes might be part of a much larger bill that then, or a much larger law act that's already been approved. And so you're going to get lots of language. When you're reviewing the bills, what you want to look for is the underlines. Underlined text is the new language. So what's new is underlined. Things that are removed are strike-throughs. So if you see text where there is a strike through a word, that means the newly proposed language would remove that language from the act or in the bill. And then everything else that is in normal text, that's language that already exists. So that causes a lot of confusion at times. People are like, well, wait, is this whole thing new? What's going on with this? When you're scrolling through the bills, underlined language is the proposed new language. Strike through means it's old language that would be removed. And plain text is language that would stay. So in this example, everything at the top you can see here, this is all new language. They didn't change the definition of third-party payer. So that you can see is in plain font or regular font. There were no changes to the definition of a third-party payer. The other thing that you can look up, right? So if you click on bills and resolutions, that's where you'll see the current bills that are proposed. If you click on public acts, you can look at the 104th General Assembly and see all of the bills that were signed by the governor that are now going to become law in Illinois. So when you look at the laws, the difference, it's a similar layout, but you can see it's public acts for the 104th General Assembly, which is 2025 to 2026, that 2-year period we talked about. And then it'll be in numerical order. The very first bill that was signed, 104-0001. The next bill that became law is 002. It will also list the original bill number. Again, it's a good way that you can look at that. 104th General Assembly. What did we see? There were a lot of healthcare bills actually that were proposed as per the norm. What I've done, this is not an exhaustive list because we don't have enough time. This really highlights a lot of the key bills that impact pharmacy practice. The 104th General Assembly stayed pretty similar. It is a supermajority for Democrats in Illinois. 40 Democrats, 19 Republicans in the Senate, 77 and 40 in the House. Like I said, we reviewed in 2025, there were 6,821 bills proposed. We typically are initially screen about 300 bills that deal with healthcare, and we narrow that down. And again, it's 2025 to 2026 is the 104th General Assembly. So now we're going to talk about some actual acts that got approved. In terms of Public Act 104-27, this was the Prescription Drug Affordability Act. It's really what we would call the PBM Reform Act in Illinois. This was the one that the governor was talking about. We had it in the State of the State address by Governor Pritzker. We had Ann Gillespie, who is a senator or was a senator in Illinois, who is now the head of the Department of Insurance, that was a strong proponent of this. It really is an attempt to reel in some of the PBM abuses that occur in the system. PBMs are necessary. They are an important part of the healthcare system, but they really leverage the power that they have. In the opinion of many pharmacy organizations and pharmacists and technicians, they leverage that power inappropriately. And so this is an attempt to reel in some of that leverage or some of the practices that they have that aren't fair to pharmacies and that aren't fair to our patients. Number one is it's increasing PBM reporting requirements. As of August 1st, 2025, they have each health benefit plan that they administer, they have to have a listing. They have to list the number of individuals that they cover and the total number of people that they cover across all their plans. Why do they need this? This is unique to Illinois. The Department of Insurance, along with the pharmacy organizations, ICHP, IPHA, and IRMA, negotiated that PBMs have to pay a $15 per covered member fee to the Department of Insurance to help cover some of the administrative costs and to provide better reimbursement for pharmacies. There are now some contractual and operational restrictions on PBMs too. Steering is prohibited in this act. So one of the things that I'm going to say repeatedly here, if you notice that PBMs after January 1st, 2026 are continuing to steer patients, they are continuing to play rebate games, and some of these things, we should talk, and it might require a complaint being filed with the Department of Insurance. Now, the way that there's a little bit of a ramp up period is it's for new contracts after January 1st, 2026. So if you signed a contract in June of 2025 and it doesn't expire until June of 2026, technically the PBM can continue their old practices until there's a new contract in place or a revised contract in place. But steering is prohibited. They can't play games with specialty definition. It has to be a commonly accepted specialty drug with a known limited distribution system in order for the PBM to limit access. Rebates. All the rebates have to go back to the plan. 100% have to go back to the plan. The Department of Insurance can audit the PBMs to a much fuller extent. And again, like I said, this all goes into place January 1st, 2026. But it's any plan that is amended, issued, or renewed after 2026. So if the PBM is still acting on an old contract, they don't have to comply. But if they amend, issue, or change the contract in any way after January 1st, they need to comply with these requirements. If they're not, work with your legal department, work with your government relations people, and with ICHP. And we can talk about, should you file a complaint with the Department of Insurance that X PBM is not following the requirement. Another change that we saw is a change in the eye drop, the drug repository system that pharmacists can participate in and pharmacies can participate in. Really, the big updates to eye drop were that the state is now going to provide some more resources. How long it takes to get those resources is a good question. But for instance, there's going to be a website that lists pharmacies and other organizations that participate in eye drop. There's going to be some more guidance for patients on eye drop as well. And so that should be coming. I don't know that there's a large number of health system pharmacies that do participate in the eye drop program, but it is something that people might ask your pharmacy about. Another change is in the Hypodermic Needles Act. The 100 syringe limit still applies, so pharmacies can still dispense 100 syringes. What they added, though, is if a pharmacy has the sterile syringes or needles in stock, and in their professional and clinical judgment, a patient is in need of them, the pharmacy shall sell them syringes. So this is if there's a legitimate clinical need for those syringes. The patient has diabetes and they say, hey, I'm out of syringes. They have diabetes and they're asking for insulin syringes. The pharmacy, it's not well, we don't really do that. You need to find someplace else. The pharmacy is supposed to support that patient by selling them a reasonable amount, under 100, of sterile syringes for that clinical use. So it adds the clinical language or clinical judgment. If a pharmacist thinks it's for a nefarious purpose, the pharmacist does not have to sell everybody who comes into the store syringes. However, if the person has a condition where the pharmacist knows that the person uses injectable products and they say they need syringes, you would have to have a really good reason if you have them in stock sitting on your shelf why you're not going to sell them to that individual. Public Act 104-252 updated the Controlled Substances Act. Long story short here, if a patient has a prescription for an ephedrine isomer, so pseudoephedrine or ephedrine itself, typically, the limits on quantity dispensed by the pharmacy for OTC purchase do not apply in Illinois. So what was happening is a lot of physicians were prescribing pseudoephedrine or other ephedrine isomers to patients. They would have a prescription for a clinically appropriate dose, and the pharmacy would say, well, we can't dispense that because it's above the limits of what we're allowed to dispense. This act now tries to get around that by saying, you know what? If it's clinically appropriate, that's key. A pharmacist does still not have to dispense a clinically inappropriate prescription for ephedrine. If there's a question on the validity of the prescription, that's a different story. But if it's a valid, reasonable clinical quantity of ephedrine product and there's a prescription for it, the limits on quantity do not apply in Illinois. I think one of the things that might cause an issue with this is how quickly does the DEA in Illinois respond to this change? This is another update. It's Public Act 104-271 on methamphetamine precursors. It's really looking at the quantity. It used to be 2 targeted packages. Now there are very specific gram amounts that can be dispensed over the counter. So 3.6 grams per day or 7.5 grams in a 30-day period for those methamphetamine potential precursors. So again, probably less impact unless you're working in a health system in a retail setting. This will apply to you. Within the hospital, it's less likely, right? An inpatient pharmacy, this is much less likely to apply. Public Act 104-312, expansion of pharmacist-provided contraceptive therapy. What this did is this struck, the old act was only applied to hormonal contraceptives. This now allows for a broader set, it's just contraceptive access through pharmacists. The other thing that it does, this is a little bit of the controversial depending on your beliefs, but it does also include emergency contraceptives through pharmacists as well. So it is an Illinois law that now pharmacists can provide through the pharmacist only, in that standing order, emergency contraception as well. Public Act 104336 is another one that has an impact more in the community than probably in the health system, but it's important to know. In rural areas, it's getting harder and harder for hospice and other providers of in-home therapy because of there's less providers and there's large distances to travel. This bill, when Government Affairs first reviewed it with ICHP, had some concerns, but through discussion and understanding in rural communities what's happening, there's still concerns that ICHP has with this bill, but it's really probably a necessary bill to help maintain access to care. What this does is it allows hospice employees. So if you're an employee of a hospice company, you are able to pick up a controlled substance for a hospice patient and get it to their home. So it used to be that they had to be a hospice nurse or a more regulated employee of the hospice company. Now, any employee of a hospice company can pick up that drug. Now, what I want to say is, because that initially is, can be, depending on your stance, can be a little bit concerning. In no way, shape, or form does this bill prevent a pharmacist from validating that that person is who they say they are. If your pharmacy policy says they need to provide credentials to say they are really a hospice employee, if you don't know them, that is completely acceptable. But you can't just outright prevent a hospice employee from picking up the drug because that's against your policy. You still can put process in place to validate the legitimacy of the person who is picking up that prescription. Just be aware that hospice, transporters or hospice, supply transporters may now be coming in to pick up controlled substance prescriptions for the patients. If you can validate that they truly are an employee of that company, law supports them being able to do so. Public Act 104-369. This is an act that really is trying to get insurers and others to put non-opioid pain meds on the same level as opioid pain meds. This was a little bit driven by a manufacturer who now has a non-opioid alternative for acute pain. We're going to keep this non-branded. I'm sure many of you on the call know what I'm referring to. However, there are some good things in this bill that would say the Department of Public Health they're going to put together a pamphlet that outlines non-pharmacologic and non-opioid alternatives for pain management. That's a good thing, right? Anytime pain management can be achieved by non-opioids, that's probably a good thing for our patients. The other thing it does that's a little bit controversial, it says that these non-opioids can't be disadvantaged on a formulary by insurance companies. They cannot disadvantage any non-opioid that has equal efficacy versus an opioid product just because it's cheaper. There were some concerns on the Government Affairs Division within ICHP that, isn't that kind of forcing formulary status for one drug right now? And there is some validity to that. But overall, encouraging insurance companies to cover non-opioids, the benefits seem to outweigh that little bit of a drawback. The other thing is it does address the public aid code as well, trying to make sure that coverage is ensured. Public Act 104-432, this really looks to, I'm going to try not to make this political, but there are some politics in it. We can't separate it. A little bit of this is to address what's happening in HHS, the FDA, and the CDC. This Public Act 104-0432 is really to address the removal of FDA approval for things like COVID vaccine that last year had certain approvals that next year might not. That the World Health Organization or ACOG or other experts might recommend that the FDA or the CDC are no longer recommending. Or I'll just say it, misoprostol or other drugs are also in this category. And so it's an attempt by the state of Illinois to ensure that drugs that were FDA approved in the past or had CDC or FDA recommendations for use, that if there is a somewhat arbitrary removal of those requirements, that the state can still fall back on coverage based on the old recommendations. So that is what this attempts to address. We could talk about this for an hour in and of itself, but I think I'm going to leave it at that. The other thing that it does, though, is it does also provide protections for Illinois practitioners if you're in the process of providing something that the WHO recommends or the primary literature supports, that IDFPR is not going to come after you solely based on the fact that the CDC is no longer recommending that therapy. That if there's good evidence to support it, there are other expert organizations that support that recommendation. That is not a reason that the IDFPR would come after you or your license. There are also some other acts that were passed that I included that I recommend people check out that have an impact but aren't directly, as closely impactful for pharmacy. One thing I do want to say, I have a mistake in my handout. Public Act 104-244. So the third one down does not deal with controlled substances. It actually deals with outpatient birthing services. So there's an expansion in the birthing services in the outpatient setting or out of hospital setting that APRNs can provide, and that is what that deals with. The veterinary controlled substances changes that you see in 424 that I put in there twice. Again, I apologize. I don't know what I did when I was putting together this slide. That one really has to do with the electronic prescribing. They added some additional exclusions for the electronic prescription requirement for veterinary practitioners. So when it comes to advocacy, getting everybody involved is the best way that we see things change. You reaching out on a grassroots effort to your individual legislators, organizations like ICHP fighting for change and making sure people are aware of what change is needed, and then engaging our lobbyists who have their ears to the ground in Springfield. We're going to continue to work on PBM reform. Somebody might say, well, why? We already got the bill. PBMs are going to find ways around the legislation. They're going to call it something else. They're going to get creative. We're going to continue to work on prohibiting mandated white bagging and brown bagging, provider status and reimbursement, the technician education and CE requirements, 340B protections. We got to keep fighting for those. There's going to be more revisions to rules. And we're also going to keep working on licensing delays and any other topics that come up. Quick assessment questions. What topic did Senate Bill 3225 try to address? So this is we didn't cover this one. This is one you're going to have to go to ilga.gov/legislation to look up. It is actually white bagging. So Senate Bill 3225 tried to address white bagging. It didn't make it this year. It's going to be back. The other thing I'm going to say, I'm going to try to work with the Department of Insurance. I think there is a way in the language that we might be able to say white bagging requirements are patient steering. It's requiring a pharmacy to use a pharmacy that's outside the patient's choice. I'm going to see if the Department of Insurance agrees with us on that. The next assessment question, what did Public Act 0027 on PBM reform do? Or what are its goals? What should it accomplish? Yep, I see people dialing in. It's really all of the above. So it's really all of those things. These are not all the things it does, but these are some of the big aspects of what it does. So with that, let's take a look at some of the questions in the chat. So I see the yikes in terms of the fees. I agree with that. In terms of, is there still time to influence some of these changes before they're enacted? No, the comment period is over. We're now waiting to see what comments that IDFPR accepted and what changes they're willing to make. There's a question about, does the invoice that's required for drug transfer between two different pharmacies or two different health systems relate to community or practice only, or does it apply to health systems? My interpretation is it would apply to both. So if you are transferring drug between two different licensed pharmacies, it would require you to have that invoice to track what was transferred. The reason why I have that opinion, again, I always joke that I'm not a lawyer, but I play one on TV, is pharmacies are licensed as pharmacies in Illinois. There is no distinction between a hospital and an outpatient pharmacy when it comes to the license. And so my interpretation is, yes, hospital pharmacies would also have to track that. Can you please explain more about the iDrop program? Yes. So the goal of the iDrop program, there's a lot of drug waste in the U.S. health system. There's also a lot of, people who don't have resources for expensive drugs. The iDrop program's goal is that there would be a repository in the state of Illinois. As an example, I get prescribed, I'll just keep it in ID. I get prescribed linezolid for an outpatient infection, and it's a 2-week prescription. I take it for 3 days and I have side effects and I can't tolerate it. In the old system, that linezolid would just be, right, thrown in the trash. Well, hopefully not the trash, disposed of appropriately, but it would be out of the medical system, right? iDrop would allow that linezolid to be donated. And then when a patient had a prescription for linezolid, they didn't have the resources for it. They potentially could get access to those linezolid tablets through the iDrop program at a repository participant. So that's the goal, is to quit throwing drugs away that have their integrity and are good drugs. Quit throwing them away just because they're no longer needed, or the therapy changes, or the various reasons that can occur. I see another question. When will pharmacists get different licenses so we can have a prescriber or practitioner license? I think that's kind of some of the next steps, Pete. One of the things that Government Affairs is looking to do, Scott Drabant and now Joanne Stubbings is the Director of Government Affairs. We are looking at standard of care, right? That's a buzzword right now. So standard of care and independent practice authority. States are starting to look at that, about how can we allow pharmacists to practice not at an even set level for all pharmacists, but a level based on your experience, training, and education, right? Pharmacists in general can provide many clinical services, right? But not all pharmacists are necessarily qualified to be a transplant pharmacist working in a solid organ transplant clinic at a academic medical center, right? Now, I don't want to get into the political discussion of pharmacist training and education, but standard of care would say, hey, if you've completed a PGY2 residency and you've been practicing in transplant, there's probably things you can do in that transplant clinic that maybe a pharmacist like me, who's ID trained, shouldn't be doing, right? Or couldn't do. So closer to kind of the physician model, where yes, there's going to be a base level of clinical services that maybe all pharmacists can provide, but with standard of care and independent practice authority, there are going to be varied levels of expertise in our pharmacists that then might require, right, different credentials to practice in different ways. Whether that'll be in the licensing, though, there's a little bit of a risk there too. I don't know that we want the state determining what pharmacists can do versus maybe the health systems and their credentialing and privileging departments. I would feel more comfortable if it's the medical staff and somebody in your organization that says pharmacists who meet these criteria are able to work in the anticoagulation clinic and be independent prescribers. People who do XYZ, right? Lipids or continuous glucose monitors, right? We could go all different places. I think credentialing and privileging in organizations is probably maybe a safer bet than saying the state has a license that allows you to do certain things. But again, I think that's all to be determined as we continue to move along that path. The other thing I would say, Illinois is not always the quickest to adopt change. I think that's changing maybe a little bit. I think Illinois is a leader in some aspects, but we'll have to see what is the appetite in Illinois for that kind of change within IDFPR, for instance. So we're going to work on it is the answer. And I think we will eventually get someplace. What exactly it's going to look like, though, I think it could be any of those extremes, from the state determining the licensure all the way over. And Scott put the definition in the chat there of the degree, or what is standard of care. It really has to do with education, training, and experience, right? So what that says too is a pharmacist who maybe initially isn't qualified to do something. Again, that's a delicate subject. I know I'm not, there's two camps there. But let's say right now for me, I'm an ID pharmacist. The therapeutic issue of vaccination is not an issue. But right now, I don't have the experience or the training to vaccinate. If I was going to vaccinate people in order to meet the standard of care, I would need to do a little bit more training and maybe spend a day or two with a practitioner who can vaccinate to vaccinate a few people while I'm being observed and some other things to be qualified, right? That's what standard of care is. It doesn't mean, oh, you're a PharmD and you're not qualified. It would mean, hey, Chris, if you haven't vaccinated anybody in a really long time, you need to figure out what you need to do to sharpen your skills again and make sure you're up to date. So that's kind of what the NABP definition is trying to highlight. I want to thank everybody for their time. I'm really encouraged that we had so many, like I said, so many people on the law review call. The other thing I would say, I am your resource as ICHP's EVP. If the law is giving you trouble, the interpretation of the law is giving you trouble, I want you to reach out to me with an email or a phone call to say, hey, Chris, I'm trying to interpret how this might apply. I'm happy to try to work through it with you. Like I said, I'm not a lawyer, but I deal with it a lot, and I'm always happy to try to work through questions with people. If I can't answer it, I can talk to the state. I can talk to pharmacy directors across the state about how have you managed this? What do you do? So we can try to help you solve your problems a little bit quicker. All right, I'm not seeing any more questions. So again, thank you everyone and have a great rest of your day. And thank you for engaging with ICHP.